Well, it's a great pleasure to welcome a very distinguished guest tonight, Justice Douglas Ginsburg, who is a distinguished American jurist. In the course of his career, Judge Ginsburg has been a professor of law at Harvard University. He's held a number of posts in the executive branch of the federal government, including Assistant Attorney General for Antitrust in the U.S. Department of Justice. And then in 1986, he was appointed to the United States Court of Appeals by President Ronald Reagan and served as chief judge of that court from 2001 until 2008. Judge Ginsburg joined the George Mason Law Faculty as professor of law in July 2013 and continues also to serve as senior circuit judge on the United States Court of Appeals for the District of Columbia. He's held teaching positions in a number of law faculties, both in the United States and internationally. Judge Ginsburg is a leading authority on competition law and policy, administrative law and economics. And it's a great pleasure to welcome him to the CIS this evening. But he's here to talk about something slightly different, to address a slightly different question. What is it that judges actually do with the law? Do they discover it or do they create it? And can the common law exist in the event that judges are silent about it? So are judges legal declarationists or are they legal creationists? Judge Ginsburg will guide us through the issues. Will you please welcome him now?
That's a lovely introduction. I appreciate it. Almost, I think if it weren't required to, I'd actually stay. All right, so that is the question I want to address, and it's probably a new question in the minds of some of you, or the experience of some of you, but it's really quite a venerable question in the common law world. In Law, Legislation, and Liberty, Friedrich Hayek offered a rather sophisticated account of the view that judges discover the law, explaining that the rules that judges announce are, quote, derived from the conditions of a spontaneous order which man has not made, close quote. Legal rules, according to Hayek, are discovered either in the sense that they're again speaking through Hayek, either in the sense that they are merely articulate, already observed practices, or are found to be required complements of the already established rules if the order which rests on them is to operate smoothly and efficiently. Now, when Hayek posited that a judge discovers, and this is largely common law, I'll explain that in a moment, that a judge discovers rather than creates the law, he was tapping into an idea that has a rich intellectual history, in fact. And I'll briefly trace that history of the debate about whether the law is discovered or created by common law judges, then expand upon Hayek's account of how judges discover the law, and offer some observations based on my own experiences of these last many years. So first, I'd like to note that Hayek was contemplating the role of a judge in a common law system quite explicitly. A system in which individual cases are resolved in accordance with legal rules deduced from prior court decisions, which are treated as either binding or persuasive precedents, depending upon how similar the facts of those prior cases were. A common law system stands in contrast to a civil law system where the law is composed as rules codified by the legislature. Now, today, the Napoleonic system being the primary example on the continent, today a lot of law is statutory even in common law countries, such as this. Indeed, principally the United Kingdom and its former colonies. Statutory law is clearly created, obviously created, rather than discovered. The legislature decides what the law ought to be, and the law has force because it's the product of the legislative process. The discussion about whether a judge discovers the law or creates it, therefore, focuses on cases in which the applicable rule of decision is not supplied by a statute. Now, in common law jurisdictions, and this is basically the English-speaking world and some extensions there, in common law jurisdictions, most of the law that governs the relationships among private parties, contracts, torts, property, commercial transactions, agency, all of that, is either still governed by the common law or has been codified in statutes that embody earlier common law rules and still afford the courts a good deal of discretion in deciding individual cases. In civil law countries, courts are increasingly relying upon precedents, that is, on their own prior interpretations of codified law, in applying those statutes to individual cases. The two systems are still far from converging. I wouldn't suggest that they're converging, or close. But in each, there's room for debate about whether judges create or discover the law as they resolve particular cases, primarily because the code and the fiction that the code can resolve all of the cases is simply untenable. In a civil law jurisdiction, the code runs out long before, in many cases, long before the matter can be resolved, and the court has to decide how to apply the code to the particular facts. In the common law world, we often have statutes that are so open-textured that they really don't depart in any substantial way from the common law methodology. In my principal field of competition law, the Sherman Act of 1890 in the United States has two principal sentences. The first and most important of which is that any combination, contract, or conspiracy in restraint of trade is unlawful, and the rest is up to the judges. It's been 125 years now. There's a great deal of learning on the subject, but that broad statement doesn't really resolve any cases. After the first few, in which the Supreme Court of the United States said, well, it can't be taken literally because every contract is a restraint of trade. It obligates the parties to perform in a certain way going forward. So we'll read the word unreasonable into it. And indeed, there was a common law doctrine of unreasonable restraints of trade inherited from the United Kingdom. And so even that technically statutory law is essentially 99.9% case law, not statutory. Before the 19th century, most scholars of the common law believed that judges indeed discovered the law rather than creating it. And this view is most commonly associated with the English judge and commentator William Blackstone, who wrote his treatise, multi-volume commentaries on the common law in 1765. He wrote, quote, that the judge is, quote, a living oracle who is not delegated to pronounce a new law, but to maintain and expound the old one. Now, this declaratory theory, if you will, of Blackstone's is premised on the idea that the law exists independent of the judge's articulation of it. So a judicial decision is just the as he called it, the principal and most authoritative evidence of the law. But the law and the opinion of the judge are not always one and the same thing, since it sometimes happens that the judge may make a mistake of the law. And indeed, then when one case overrules another, it's not because it's because the judge in the first case made a mistake, not because the law has changed or that the second case the judge is changing the law. That was the way in which Blackstone presented this. Now it's a little hard to take in its raw form. But if we ask what judges, common law judges like in Blackstone himself, what they meant when they instanced the existence of a law outside of their own decisions, which they were only discovering, there's a deep history to it. During the Middle Ages, most courts were, in fact, in the United Kingdom, in England, were informal local tribunals that adjudicated disputes according to custom, to the long-established custom. which was often described by live witnesses who were familiar with the relevant practice, and the practice varied from one place to another. And indeed, the common law was not called the common law because it was common to all of these locations, but because it was coming up from the people. It was the common practices of the people that made it the common law. So the judge discovered the law, therefore, by learning about the custom and deciding how the dispute should be resolved according to prevailing community norms. Now, a contemporary of ours, Professor Keith Hilton at Boston University, explained it this way. Judges discovered the common law in the same sense that an arbitrator in a contract dispute might search for the rule that the parties would have adopted if transaction costs had not prevented them from explicitly adopting it. The body of such rules existed independently of the courts. The judges were mere spectators who were sometimes called upon to find the rule that should govern the dispute. By the 15th century, though, more powerful centralized governments had created their own courts that displaced these local tribunals. These newer courts, these governmental courts, were unfamiliar with local practices. They had a larger territorial span, often requiring people to come to the capital or a large town. And so they increasingly relied upon general ideas about reason, equity, and natural law in lieu of observed custom. Although the judges no longer decided most cases by discovering local norms, they still maintained that they were finding a rule in a long-established customary practice rather than creating it anew. A judge's proclamation that he was merely discovering ancient custom was not always historically accurate because judges were by then unfamiliar with customary practices, and in any event, ancient customs didn't always dictate an answer to a contemporary question. Technology changes, other things change, and new questions arise. It was, however, a useful fiction and likely was conducive to liberty. Former judge in the United States, Michael McConnell, explained it this way: if the rights of the people have their origin in a grant from the king, then those rights are vulnerable to revocation by the king. On the other hand, if rights have their source and authority in long-standing practice, they are not vulnerable to the will of the sovereign. Only custom, that is, changes in practice manifested over a long period of time, could change custom. And it's widely agreed, I think, that the common law is associated with a decentralized system, one in which liberty is better preserved than the civil law system in which the sovereign dictates through a code what the law will be. Well, the view that judges discovered the law came under heavy attack in the 18th and 19th centuries. First from utilitarians, notably Jeremy Bentham, and then his disciple John Austin. I think it was Bentham who said that this was all nonsense on stilts, which would be the equivalent today of nonsense on steroids, I guess. John Austin, who was a disciple of his, he lampooned what he's called the childish fiction employed by our judges, that judiciary or common law is not made by them, but is a miraculous something made by nobody, existing, I suppose, from eternity, and merely declared from time to time by the judges. The heated dispute, and by the way, they were, Austin in particular and Bentham, particularly of the view that the sovereign should be writing codes and prescribing the law in details. Bentham outlined volumes of the codes that he would have had seen enacted. And it was Austin's view that anything that was enacted by the legislature was the law, and nothing that was not at least approved by the legislature was the law. And so there was no limit on what the law might be because of parliamentary supremacy. This dispute was part of a broader conflict, if you will, or contest between the proponents of common law and what became a very prominent 19th century movement towards codification, which occurred in the U.S. as well. Judge Richard Posner, another American judge, one of the people with whom I studied, attacked. He explained that Bentham attacked the common law judge's reliance on the rhetoric of discovery in order to undermine the legitimacy of common law rulemaking by making it appear that the judges created the law out of whole cloth rather than established custom. And by discrediting the common law, Bentham wanted to clear the way for codification. Indeed, codification, in his case, specifically embodying the policies that he deduced from his greatest happiness principle, which the legislature could speedily enact to take the place of whatever common law doctrines might be in the illegitimate occupation of the field at that time. Today, many scholars and probably many judges reflexively reject the idea that judges discover the law rather than create it. One author writes that the declaratory theory, that is to say Blackstone, does not accord with modern moral understanding of the democratic political ethic. Another says that the whole idea now seems anachronistic, and so on. So these critics are correct, I think, to point out that judges no longer believe there's a universally applicable natural law waiting to be identified by deductive reasoning. But the critics often overlook the role of custom in shaping the development of the common law or the application of statutes that give judges substantial discretion in their application. Relying on custom is a mode of decision-making that's neither contrary to democratic political ethic nor anachronistic, and with a few examples, I'm confident you'll agree. Consider how a judge decides whether a doctor violated the standard of care owed to his patient in a medical malpractice case, or whether a party upheld his end of a bargain under an ambiguous provision in a contract. In the medical malpractice case, the judge would ascertain what is the customary practice of doctors under those circumstances, the circumstances of the patient and plaintiff in front of him, in his local area and in that specialized field of medicine. That would be, and witnesses would be produced, expert witnesses, to testify about what the standard of care is, other doctors. Plaintiff would have to show that the defendant doctor departed from the customary practice if he's to have any chance of prevailing. In the contract case that I instanced, the judge would determine the reasonable expectations of the parties in light of the customary practices in their trade or their industry. In both cases, the judge is endeavoring to understand whether the parties adhered to the standards customary in the relevant community, and to reach a result that gives similarly situated parties an incentive to conform their behavior to those practices in the future. Now, today, these cases might arise under a statute, such as the Uniform Commercial Code in the U.S., adopted by all but one of the states. But the Uniform Commercial Code is full of common law license, if you will. It contains efforts to codify common law rules, to take them as they were in the drafting period in the 1940s and 50s, and write them down, based on the premise that unwritten customs and usages in the trade exist, and that in commercial disputes they should be and can be discovered and applied by the courts. And indeed, they're then glossed with a general obligation of good faith dealing, leaving the court a good deal of opportunity to determine whether someone in fact departed from the custom, and maybe they didn't in a technical way, but they did in a way that should prevent them from prevailing. Now, there's no guarantee that a code will accurately reflect the customs, even of the day that it's drafted. The Uniform Commercial Code was drafted by distinguished academics and lawyers. It took a long period of time, but it lacked a solid empirical research foundation which led the drafters to adopt provisions that actually in some instances were detrimental rather than accommodating to merchant concerns, and led to a commercial law that was based on a deeply flawed understanding of merchant reality in some areas. So as the notion that judges create the law reached its zenith in the United States, so the idea of discovery is at its nadir, creation is at its zenith, Bruno Leone steps forward, who influenced Hayek's ideas in law, legislation, and liberty, and breathed new life into the idea that judges discover the law. He was writing this in 1961 when he described the judge's role in Roman private law and in English common law, which he said shared the idea that the law is something to be discovered more than to be enacted. Now, Leone understood that there were several important structural features in the common law courts that caused their decisions to resemble discoveries rather than creations. And perhaps the most important, a judge decided only the case brought before him, such that he was a mere spectator rather than an actor, to use Leone's terms. Unlike a legislator, a judge did not seek out a perceived problem and then craft a proposed solution. A problem was brought to him. He would be forced to craft a solution, ideally as narrow a solution as possible, to resolve the matter. So the judges still had their own subjective preferences, still do. There's no denying that. But they cannot enact arbitrary rules of their own in the usual sudden, widely ranging, and imperious manner of legislators. That's Leone speaking. Because they could only decide the cases that two citizens chose to put in front of them. And because judges proceed on a case-by-case basis, unlike legislators, Leone conceived of the common law decision-making process, quote, as a sort of vast, continuous, and chiefly spontaneous collaboration between the judges and the judged in order to discover what the people's will is in a series of definite instances, a collaboration that in many respects may be compared to that existing among all the participants in a free market. One of my colleagues at George Mason University, Todd Zawicki, linked the analogy, Leone's analogy between law and the market, back to the idea that the law is discovered rather than created. He and a co-author noted that although it's true that a particular sales clerk attaches a price tag to apples in a supermarket, it would be inaccurate to suggest that the sales clerk is thereby making or creating the price of apples, as opposed to simply articulating the prevailing market price as it emerges spontaneously through millions of individual trades. Close quote. It would be likewise inaccurate to say that the judge creates law by observing customary practice and applying it to the case at hand. Now, Hayek agreed with Leone's description of the law as a spontaneous order that emerged not through direction by rulers, but through the development of customs on which the expectations of individuals could be based. Not surprisingly, he also viewed the law, quote, as something given independently of human will, something to be discovered, not made. He parted ways with Leone, though, in the extent to which he conceived the law as a series of abstract principles embedded in the custom and precedent on which the common law judges relied to decide cases. He instead quoted approvingly Lord Mansfield, the great 18th century English judge, quote, that the common law does not consist of particular cases but of general principles which are illustrated and explained by the cases. The law discovered by a judge comprises these abstract rules of conduct, close quote, which in turn are derived from customary interactions within the community. So imagine at the foundational level these customary interactions within the community, people going about their daily business, observing the norms that make things flow smoothly. Observing those activities, one can abstract away from them to articulate rules of conduct that are being observed, although no one's articulating them, none of the participants. And from those abstract rules of conduct, one can set forth legal rules to govern individual cases. That's the idea, and that's why this is a bottom-up concept. Now, in 1947, there was a very well-known leading judge on the court equivalent to mine, but in New York, named Learned Hand. And in 1947, he wrote an opinion that is an example of this kind of abstract rule of conduct that Hayek had in mind. He articulated what came to be known as the Hand formula. It posits that a person should be held liable for negligently injuring another only when the cost of taking a precaution to avoid that injury would have been less than the foreseeable cost of the injury itself, multiplied by the likelihood that it would occur. So, example, in one famous case, a homeowner sued the water company. This was a London case, an English case, after record low temperatures had caused the company's pipes to freeze and to leak and flood his home. The damage was substantial. The water company could have prevented the injury by burying the pipes more deeply in the ground, but the court decided that the water company was not negligent because it would have been very expensive to bury the pipes more deeply, and the pipes leaked only because of an unprecedented deep freeze. So if you think of the cost of that precaution, discounted by the probability of its occurring, which was very low, the result is a number less than the harm it caused. And there would have been a social waste to have incurred the cost of preventing that kind of an accident. The court explained it this way: negligence is the omission to do something which a reasonable man, guided upon those considerations that ordinarily regulate the conduct of human affairs, would do. This is very similar to Hayek's statement, declaration that the task of the judge is to tell the parties, quote, what ought to have guided their expectations, not because anyone had told them before that this was the rule, but because this was the established custom which they ought to have known. Think of the doctor in the medical malpractice case. The witness says this is the standard. The doctor should have observed that standard. Didn't do so. Liability is entailed. So the case I described, the London freezing pipes case, that occurred 100 years before Hand defined negligence in terms of a formula. I'll spare you the arithmetic. But the fact is that there are countless common law cases that embody this same principle. And after 200 years of negligence cases in the courts of the English-speaking world, there was nobody who could tell you what negligence meant. Lawyers could only tell somebody, well, I think you'll be held liable for negligence if you do that or fail to do that, or having failed to do that, we have a probability of being held liable for negligence. But no definition of what negligence was until 1940, in any meaningful sense, until 1947. Oliver Wendell Holmes, one of the most venerated judges in U.S. history, criticized the idea that law is discovered in the following terms. The common law is not a brooding omnipresence in the sky, but the articulate voice of some sovereign or quasi-sovereign that can be identified. Now, the brooding omnipresence language the sarcasm of that has persisted. It's often quoted. The reference to the voice of a sovereign or quasi-sovereign, it parrots what Austin was saying, that the law is what the sovereign said it is. It's what got Germany into a great deal of trouble in the middle of the 20th century. In Hayek's account, on the other hand, the judge does not look to the sky for an abstract principle because discovery of legal rules proceeds from the bottom up, not the top down. The legal rule is discovered in the sense that it originates in customary interactions between individuals and is observed by judges. More precisely, are brought to the attention of the judges by opposing advocates who propound alternative lessons to be drawn from experience, pointing to the prior cases and the facts about the contemporary world and drawing analogies from the cases that seem most to promote their client's interest. Customary practices, therefore, guide the judge in resolving concrete disputes which over time form the basis of a legal rule. Israel Kirzner's work in entrepreneurship offers an analogy that I rather like. We ordinarily think of a new invention that fills a niche in the market as the prototypical example of creation. There's the inventor created something. The invention is the result of the creative genius of the identifiable person who comes up with a novel idea. But before the entrepreneur can fill that niche, he has to discover it. As Kirzner describes the process, without knowing what to look for, without deploying any deliberate search technique, the entrepreneur is at all times scanning the horizon, as it were, ready to make discoveries. Close quote. These discoveries are the profit opportunities lurking in the market. Peter Betke, a colleague in the economics department at George Mason, puts it this way: the discovery process rests on the capacity of entrepreneurs to notice information that is not presently conveyed by prices and to act upon it. Close quote. The entrepreneur is an active participant, but the opportunities that he discovers exist externally in the market. Likewise, the judge is an active participant in the development of the common law, but that law often exists externally in the form of a custom that's been developed and recognized by society before it's ever discovered by the judge or proclaimed to be the law. That's why judges can sit in such a wide range of cases, because they are informed about the customs of the community by the opposing lawyers. And hear a contract case one day and a medical malpractice the next day, and they don't have any medical expertise in order to do that. They don't need it. Hayek's account also expands on the notion that judges discover the law in a way that more fully explains the evolutionary development of the law over time. One of the frequently heard criticisms of Blackstone's declaratory theory is that common law judges often thought that all custom was, by definition, immemorial, such that it was fixed and unchanging. When a court overruled one of its earlier decisions, Blackstone said, as I mentioned, that it was just correcting a mistake and aligning the rule with the law as it always has been. That view does not fully account for the way that new legal questions continuously arise due to technological and social changes that could not have been foreseen by prior generations. A judge is often called upon to apply familiar principles to new questions brought about by those changed technological and social circumstances. And it's just such changes that prompt litigation over the application of the incumbent rule to the new circumstances. Basic economic principles provide many of the abstract rules that undergird the common law. In my view, the twin aims of reducing transaction costs and providing better incentives are central to common law decision-making. If the court creates a rule with unproductive or destructive incentives, it's going to contribute to a malfunction in society. But I don't think one has to to accept the notion that judges discover the law, though, in order to conclude that economics is a part of the substructure of the common law. As I mentioned at the outset, Hayek recognized that not all legal rules are merely customary practice when he explained that legal rules are, quote, discovered either in the sense that they merely articulate already observed practices or are found to be required complements of the already established rules if the order which rests on them is to operate smoothly and efficiently. So in the first category, rules that give expression to observed practices, we might find customary matters, customary practices that are themselves efficient because they're the product of individuals developing workable private arrangements over the course of time. The legal rules just incorporate those practices. In the second category, the rules necessary for society to operate smoothly and efficiently, we might find legal rules that provide the basic framework for market activities by reducing transaction costs and providing appropriate incentives. So Hayek uses the word discovery But the identification of rules necessary for society to operate smoothly and efficiently might be better characterized as a process, and this is really my thesis, a process both of discovery and of creation. The rules are created because they wouldn't exist if they were not announced by a court. These are not the customary rules. These are the complements that make customary rules work. But they're also discovered because the court tries to identify the rules that best complement and support the private order. In other words, the legal rules are created by a process that looks a lot like discovery. No one doubts, after all, that Michelangelo created his sculptures, but it was he who reputedly said, "Every block of stone has a statue inside, and it's the task of the sculptor to discover it." I think a lot of contemporary observers are inclined to reject Hayek's idea that a judge discovers the correct legal rule because they believe judges have nearly unbounded discretion. When lay people say judges create the law, they're usually suggesting that the judges are making decisions based on their personal preferences, free of external constraints. To be sure, if the question presented is an open one, then the judge has some discretion. But if he exercises that discretion in good faith, then he asks himself which rule better allows society to operate smoothly and efficiently, in Hayek's terms. And the judges today who call themselves pragmatists, I don't think would disagree with that. But there are several important institutional constraints that limit the judge's discretion to make policy. As noted, the judge can only resolve the cases that are presented to him by parties with a concrete stake in the matter. And at least in the adversarial system, he ordinarily consider only the arguments and the evidence that those parties put forward. Furthermore, judges at least influenced by and may be bound to follow the reasoning in prior cases decided by other judges. In the end, he still may have a choice between two competing rules, each of which has a respectable pedigree. That is, the judge could get a legal justification for either choice, though they would have different effects upon incentives and transaction costs, and therefore upon the conduct of parties in future transactions. Deciding a difficult case, made difficult perhaps because its effects on private ordering, transaction costs, and incentives are not clear, is like solving a puzzle. The judge solves the puzzle by exercising his discretion in light of his experience and understanding. His solution is not unconstrained, but neither is the judge always a mere oracle through whom the law passes, as Blackstone suggested. So in closing, allow me an analogy from the realm of aesthetics. The judge's work, I suggest, is like that of an artist struggling to complete a painting. He's tried and painted over many a solution, but there's still a problem. How to pose the subject of the portrait, how to bring a landscape into better balance, whatever. He's searching for a solution, and when he finds it, we might equally say that he's discovered it or that he's created it. The synthesis is that he has solved the problem. And the analogy I give you has an historical grounding, which has just become the subject of a movie called Mr. Turner. I haven't seen it yet. In the 1830s, there was a fierce rivalry between two famous English painters of romantic landscapes, J.M.W. Turner and John Constable. And in 1833, by happenstance, they found their paintings displayed next to each other at the annual exhibition of the Royal Academy of Arts. A few days before the opening, they were both there, Turner paced back and forth looking at this gray seascape he had painted, while Constable was working frantically to complete his rather colorful piece, which he'd actually been working on for several years, not exclusively, of course. Turner suddenly and silently ran up to the canvas and placed a small daub of red paint in the middle of the gray sea, which was a buoy. And Turner's painting with its daub of red received rave reviews. It's a classic painting that's reproduced all over. Why? Because he had solved the problem. That's why. Thank you for your attention.